example is actually based to some extent on a true story. I know you can tell from the way I talk that I grew up in New York City. But when I left New York City and I moved to California, I got into farming for a while. I raised livestock, and I raised goats in particular. And I had a very prize strain of goats. My goats won prizes for milk production and conformation and so forth. And the pride of the herd was a buck. A male goat is called a buck named Tommy. And Tommy had so many successful daughters, that is, good milk goats that came from Tommy, that people used to pay lots of money to breed their females. A female goat is called a doe, to breed their does to my buck Tommy. Tommy really loved his work, and I loved the money that I got for Tommy's work. Well, suppose that one night while I was asleep, the defendant came along with his doe, and in an effort to save the stud fee that I would usually collect for allowing him to put his doe with Tommy, he sneaked into my barn and put his doe with Tommy, and Tommy bred the doe, and then he took the doe away and took the doe back to his farm. Now, I want to tell you, Tommy was a very powerful goat, and when morning came, if I wanted Tommy to work on some of my does, he'd have plenty of energy left. Tommy was always ready to work. Has this fellow who brought his doe into the barn committed a trespass to chattel or conversion? Now, what I would suggest when you're dealing with a problem of this kind is that you first decide whether one of these torts was committed, and then go the next step and decide which one it was. So let's see if one of these torts was committed by going through the essential elements. Remember, the essential elements were first, intent, second, interference with plaintiff's chattel, and third, damage. So let's start with intent. Did the defendant have the necessary intent? Well, what does intent mean? In a trespass to chattel or conversion case, intent means the desire or knowledge that the thing involved would be affected by the defendant's conduct. In this case, the thing involved is Tommy the goat, and certainly the defendant knew that Tommy would be affected because he planned on making use of Tommy. So he had the necessary intent. The next element is interference, and remember, interference means doing something with the chattel that only the rightful possessor is entitled to do. Tommy's my goat. I'm the rightful possessor. I'm the only one who's entitled to put Tommy to work on a doe. And so by doing that, this defendant interfered with my chattel. The third element is damage. Has there been any damage? Well, I told you, Tommy was full of energy in the morning and ready to work again. Tommy certainly wasn't damaged. In fact, Tommy enjoyed the experience. Was I damaged? Well, I sure was, because if this fellow hadn't brought his doe on the sly into the barn and bred her to Tommy, then I would have collected a stud fee from him, and I lost the stud fee by his act, so I was certainly damaged. He had the necessary intent. He interfered with my chattel. I was damaged. He has certainly committed one of these two torts. Which is it, trespass to chattel or conversion? Well, first of all, I don't want to sue him for conversion, because if I sue him for conversion and I win and he pays, he gets to keep Tommy. So I would only sue him for trespass to chattel anyway. But if I did sue him for conversion, the chances are a court would find that there was no conversion, that there was only a trespass to chattel. Why? Because the interference probably wasn't all that severe. After all, he used Tommy for the purpose that I would have used Tommy anyway. And because the damage wasn't that serious. Tommy's still as good as new. All it'll take to make me whole again is the money that I would have gotten for the stud service fee. So the chances are that's only a trespass to chattel. Let me change the facts a little bit. Suppose that his doe was carrying a goat disease, a sexually transmitted goat disease, and he breeds his doe to Tommy, and a few days later Tommy dies as a result of the disease. Now my chattel has been totally destroyed. You think that's serious enough to warrant a forced sale? Well, the chances are the court would conclude that it is a conversion. Why? Because the interference was very serious. He did something that ended up killing my goat. Now, the fact that he didn't intend to kill my goat really has nothing to do with it. The only intent we require is a desire or knowledge that my goat would be affected. And my goat ended up dying. That's a very serious interference, and the damage to me is very great, and The chances are, if I choose to sue for conversion, the court will conclude that a forced sale is justified and will require him to pay me whatever it is that Tommy was worth at the time he brought his dough into the barn. And of course, once he pays me that, he can have whatever's left of Tommy. Let me change the facts one more time. Suppose that he bred his dough to Tommy without my permission. Actually, if I had seen his dough, I never would have allowed him to breed her to Tommy, because I didn't think they were a good match, and I didn't think that good babies, good kids, baby goats are called kids, everybody knows that. I didn't think good kids would result from this match, from this breeding. And as a matter of fact, they didn't. He bred his dough to Tommy, and he had 5 months later, 5 months is goat gestation. 5 months later, he had two of the ugliest kids that the world has ever seen. People came from far and wide to look at those baby goats, and when they heard that the father or the sire of those baby goats was Tommy, Tommy's reputation went down, and nobody wanted to breed their dough to Tommy anymore. Well, what do you think? Has he committed just a trespass to chattel, or is it a conversion? The truth is, I don't know. I'd have to argue about it, and I think probably some judge would say it's only a trespass to chattel because all it will take to make Fins whole again is some money to pay for the damage that was done to Tommy's reputation. But probably some other judge would say Tommy has become worthless as a profit-making stud animal, and the only thing that will make Fins whole again is to require this defendant to buy Tommy at the price that he was worth at the time that the interference occurred. And really, that's the way it's going to be in a lot of the cases. You'll be able to go through the elements and decide that one of these torts was committed, and then you'll have to make an argument about whether the interference was serious enough, whether the damage was serious enough to warrant a forced sale. And that's the only real difference between trespass to chattel and conversion. Of course, I'll mention what the books all say. If the interference isn't very serious, the courts call it a mere intermeddling. A mere intermeddling. And if the interference is very serious, the courts call it an exercise of dominion and control. But please don't think for 1 minute that you can use those terms to try to figure out whether this was a trespass to chattel or a conversion, because in every case, I can refer to the interference as an intermeddling or as an exercise of dominion and control. The real key is the seriousness of the interference and the seriousness of the damage. All right, we've talked about 3 intentional invasions of property right. Let's talk about some affirmative defenses. There are 2 affirmative defenses that go by the name of necessity, and they both have the same essential elements. The affirmative defenses called necessity, or the privileges of necessity, permit the reasonable invasion of property rights in the face of an emergency. What's an emergency? An emergency is a situation that threatens lives or property and requires immediate action. If it threatens the lives or property of the general public, we call it a public emergency, and the privilege is called public necessity. If the emergency threatens the life or lives or property of an individual or a small group of individuals, the emergency is a private emergency, and the privilege is called private necessity. What's the difference? The difference is that public necessity is a complete privilege, private necessity is a limited privilege. If I burn your house down to save the town, I was acting in a public necessity, and I don't have to pay for the damage to your house. On the other hand, if I burn your house down to save myself, or to save my kids, or to save my property, I was acting in private necessity, and perhaps I'm not a trespasser, but I do have to pay for whatever damage I've caused. Remember, though, that I don't have any privilege of necessity unless I'm acting reasonably. Suppose, for example, that I've just bought a paperback novel for about $5. And it's a hot book, so hot that it bursts into flames, and I want to put out the fire, and the only bucket of water I can see is on the other side of an expensive Chagall stained glass window, and I smash the window, and I get the bucket, and I put out the fire. Have I acted in private necessity? Well, there was an emergency. My property was on fire, but was it reasonable for me to smash an expensive stained glass window to save a $5 paperback novel? Remember, we balance advantages against